Reformation of instruments. Reformation is the remedy by means of which a written instrument is amended or rectified so as to express or conform to the real agreement or intention of the parties, when by the reason of mistake, fraud, inequitable conduct, or accident, the instrument fails to express such agreement or intention. Reason for reformation. Equity orders the reformation of an instrument in order that the intention of the contracting parties may be expressed. Reformation of instrument presupposes a valid existing contract in which there had been a meeting of the minds of the parties, but the instrument drawn up and signed by them does not correctly express the terms of their agreement. Learning objectives. At the end of this lesson, the students are expected to understand the concept of reformation of instrument, determine the kinds of contracts whose instruments can be performed, learn the applicable provision of law governing reformation of instruments, and decide on cases involving reformation of instruments. Reformation of instrument. Overview. There are contracts that sometimes, even though there is a meeting of minds between parties, do not show their true intention, which could be either due to fraud, accident, mistake, or inequitable conduct. In this case, reformation of instrument can be done in order to express the true agreement of the parties. This module will detail the kinds of contracts whose instrument can be subjected to reformation, which are not. Provision of law governing reformation of instrument are also discussed so that you will be knowledgeable of applicable laws in reformation of instrument. Illustrative example as well as legal opinions were also included in the module so that you will be guided on how to make decision on case concerning reformation of instrument. Let's start, learn, and grow in knowledge together.
Good day everyone, my name is Ronel Wansing. Together with my group mates, Revelin Aquino Bartolome, Joshua B. Ibay, Jiggy Trinidad, and Alexis Mendoza Santos. So the topic that we will report today is the reformation of contracts. So the meaning of reformation. Reformation is that remedy by means of which a written instrument is amended or rectified so as to express or conform to the real agreement or intention of the parties when by reason of mistake, fraud, inequitable conduct, or accident, the instrument fails to express such agreement or intention. Kapag ang kabilang partido ay namayagan sa kasunduan, ngunit ang kanilang dokumento ay naiiba sa kanilang napagkasunduan, ito ay maaaring ipabago ng kahit sinong partido. Ngunit magkaiba ang iniisip na napagkasunduan ng magkabilang panig, ang kasunduan ay maaari lamang ipawalang bisa. So, the requisites of reformation. In order that reformation be availed of as a remedy, the following requisite must be present. Number 1, there is a meeting of the minds of the parties to the contract. Number 2, the written instrument does not express the true agreement or intention of the parties. Number 3, the failure to express the true intention is due to mistake, fraud, inequitable conduct, or accident. Number 4, the facts upon which relief by way of reformation of the instrument is sought are put in issue by the pleadings. And the last, number 5, there is clear and convincing evidence which is more than mere preponderance of evidence of the mistake, fraud, inequitable conduct, or accident. So, in reformation, there has been a meeting of the minds of the parties. In Article 1359, Part 1, hence, a contract exists but the written instrument purporting to embody the contract does not express the true intention of the parties by reason of mistake, fraud, inequitable conduct, or accident. Under the technical rules of law, the real contract cannot be enforced until it's reformed. In annulment, there has been no meeting of the minds, the consent of one of the parties being vitiated by mistake. Reformation and annulment are thus inconsistent with each other, while the first gives to life a contract upon certain conditions. The second involves a complete nullification of it. So in Article 1360, the principles of the general law on the reformation of the instrument are hereby adopted in so far as they are not in conflict with the provision of this code. So sa Artikulo 1360 po, ang prinsipyo ng pangkalahatang batas sa reformasyon ng instrumento ay pinagtitibay hanggat ito ay hindi laban sa probisyon ng kodigo or sa code of conduct. So, the principles of the law on reformation. In case of conflict between the provisions of the new civil code and the principles of the general law in the reformation, the former prevail. The latter will have only suppletory effect. The requisites of reformation in Article 1360, number 1, there must have been a meeting of the minds parties to the contract. So the chapter of Repormation of Instruments is based on American law. The prevailing jurisprudence in America will be persuasive but not necessarily binding, provided the same does not contradict with the provisions of the code and other Philippine laws. The governing law is Article 17. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good custom shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in a foreign country. So that's all, and the next reporter will be G.K. Trinidad.
Article 1361. When a mutual mistake of the parties causes the failure of the instrument to disclose the real agreement, said instrument may be reformed. Kapag ang parehong pagkakamali ng mga partido ay nagdulot ng pagkabigo ng instrumento na iyayag ang tunay na kasunduan, ang nasabing instrumento ay maaaring baguhin. Reformation is a remedy in equity by means of which a written instrument is made or construed so as to express or confirm the real intention of the parties when some error or mistake is committed. This article applies when the mistake is mutual, that is, both parties committed the same mistake which caused the failure of the instrument to express their true agreement. Well, Article 1361 provides for a situation kung saan mayroong mutual mistake. Later on, already discussed yung situation where a new mistake is unilateral under Article 1362 and Article 1363. As we proceed with our discussion dito, dapat yung mistake must be mutual tapos it must be opaque. So, hindi dapat mistake of law. Sabi naman, it's as simple as saying pag nagkaroon ng mutual mistake, then it causes the failure of the instrument to disclose kung ano yung tunay na agreement ng parties, then your instrument may be reformed. example of Article 1361. Jack sold his civic car to Rose. Written instrument provides for the fortuner due to mutual mistake. For example, si Jack ay binebenta niya ang kanyang civic na sasakyan, which is yun din talaga ang gustong bilhin ni Rose. But doon sa written agreement nila, ay ang naibenta ay ang fortuner kasi nung nagdadraft na sila ng written instrument, nalimutan na nila parehas kung ano nga ba ang specific details ng sasakyan na bibili ni Rose, like plate number nito. So, ang nailagay ang definition ng fortuner. So, by mutual mistake ng dalawa, hindi nag-reflect ang true or real agreement yung written instrument na ginawa ng dalawa. And according to Article 1361, yung written instrument may be reformed. Either of the parties may file for reformation. Article 1362. If one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. In this article, the mistake is unilateral, but the other party acted fraudulently or inequitably. The right to ask for reformation is granted only to the party who was mistaken, since the mistake is not mutual. Kapag ang isang partido ay nagkamali at ang kabila naman ay nakagawa ng pandaraya o sa di patas na paraan na ang kasunduan ay hindi naglalaman ng tunay nilang intensyon, ang kabilang partido ay maaaring humiling na baguhin ang kasunduan. For example, Article 1362. Jack borrowed money from Rose worth 100,000. Then Rose drafted a promissory note. She wrote 1 million in the promissory note instead of 100,000. And Jack didn't notice that and he signed. So, here one after mistake or one committed mistake in signing an instrument and other acted fraudulently kasi nilagay niya is 1 million pesos instead of 100,000 pesos. So, dito ang true agreement is that Jack borrowed only 100,000 pesos, but the instrument does not express the true agreement of the parties, and the instrument express that the debt ni Jack is 1 million pesos. The reformation here is available as a remedy to Jack only because Jack is the party mistaken and mistake is not mutual, and Jack is innocent. The person who acted by mistake may ask for reformation of the instrument. Remember here that after meeting of minds, one of the parties acted fraudulently.
Hey everyone, I am Joshua B. Ibay from BSBA 3D Group 6, reporting for our final output in obligation of contracts. My part is to discuss about Article 1363 and Article 1364. Let's begin with the Article 1363. If when the instrument did not state the agreement but concealed the fact from the former, the instrument may be reformed. Let's move on the Article 1364. When through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument of the or of the clerk or typist, the instrument does not express the true intention of the parties, the court may order that the instrument may be reformed or be reformed. Kapag ang kontrata ay ay may nilalaman or mayroong isang pagkakamali, ang korte ay maaari mag-utos na ito ay ayusin o baguhin upang maiwasan ang hindi tamang or injustice sa dalawang partido. Balikan natin ang example case kanina kung saan si Ibay ay magbabayad ng 10% mula sa kanyang total na utang na 10,000 mula kay Cupido kada linggo. Kung saan hindi nakalagay na ang 10% na yon ay interest. Nainterpreta ang 10% na yon bilang bayad sa kabuuang 10,000 ni Ibay kay Cupido. Dito, kapag napatunayan na ang kontra ay mali o nagkamali mula by mistake, sabi nga, ay ito ay re-reformahin ng korte upang makapagbigay linaw sa dalawang partido kung ano ba talaga intensyon nilang dalawa mula sa kontrata, upang mapagbigyan ng mutual agreement kung saan silang dalawa ay magsasang-ayon. Ito lamang ang aking report para sa Article 1363 at 1364. Ang pinapatukoy sa artikulo na to na kung saan na mayroong itinatagong katotohanan o may nilalamang tinatagong katotohanan sa loob ng kontrata, ito ay titignan ng korte kung ito ba isa lamang pagkakamali o isang intensyonal mula sa kabilang partido. Dahil kapag ito ay pagkakamali lamang, ay dadaan ito sa tamang proseso kung saan ang kontrata ay re-reformahin ng korte upang ibalanse ang dalawang partido upang maiwasan ang injustice para sa kanilang dalawa. Ngunit kapag ito ay napatunayan na ang kabilang partido ay mayroong hindi tamang or may ill intention sa kontratang ito, sila ay mabibigyan ng kaparusahan at ang agreement o ang kontrata ay ibabaliwala. Example case, Ibay will pay 10% of his total debt of 10,000 a week to Cupido. It will last until he's paid completely. So, nakasaad dito na si Ibay magbabayad ng 10% kada linggo ng kanyang 10,000. Pero, ang hindi sinabi rito sa kontratang ito na ang 10% na yon ay interest ng kanyang utang kay Cupido. Ngayon, nagbabayad kada linggo ng 10% dahil sa akala niya ang binabayaran niya ay ang total na utang niya. So, 10% a week. So, 10 linggo mababayaran. Pero, ang 10% pala na yun ay interest lamang sa total na kanyang inutang. So, ang binabayad niya kada linggo ay napabaliwala dahil interest lang yun. Yun yung total na wala sa total na utang niya kay Cupido. Dito ngayon papasok na kung saan sa kontratang ito na mayroong tinatagong katotohanan ay isa lamang bang pagkakamali sa typing, kasi minsan na mistype o hindi na ilagay na interest yun o itong intention mula sa kabilang partido. Kapag ito ay napatutunayan na isa lamang pagkakamali ng typer o ng type, ito ay dadaan sa tamang proseso kung saan maayos ng tama naman. So the question is, what will be the remedy if one of the contract party conceal the fact from the other agreement from the other? The answer is, the party who act in a good faith may avail the remedy of reformation of agreement, since the concealment of contract mistake constitute fraud. Pero kapag ito ay napatunayan na isa itong intentional, ang agreement ay pwedeng ibasura ng korte at parusahan ang gumawa nito o yung partido na nais ng ganitong kontrata upang makapangloko ng o ilokohin ang kabilang partido. Let's move on the article 1364. When through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument of the or of the clerk or typist, the instrument does not express the true intention of the parties, the court may order that the instrument may be reformed or be reformed. Kapag ang kontrata ay minilalaman or mayroong isang pagkakamali, ang korte ay maaari mag-utos na ito ay ayusin o baguhin upang maiwasan ang hindi tamang or injustice sa dalawang partido. Balikan natin ang example case kanina kung saan si Ibay ay magbabayad ng 10% mula sa kanyang total na utang na 10,000 mula kay Cupido kada linggo. Kung saan hindi nakalagay na ang 10% na yon ay interest. Nainterpreta ang 10% na yon bilang bayad sa kabuuang 10,000 ni Ibay kay Cupido. Dito, kapag napatunayan na ang kontra ay mali o nagkamali mula by mistake, sabi nga, ay ito ay re-reformahin ng korte upang makapagbigay linaw sa dalawang partido kung ano ba talaga intensyon nilang dalawa mula sa kontrata upang mapagbigyan ng mutual agreement kung saan silang dalawa ay magsasang-ayon. Ito lamang ang aking report para sa Article 1363 at 1364.
Article 1365. Mortgage or pledge stated as sale when any of the circumstances enumerated in the law exist, an instrument purporting to be a sale with right of repurchase shall be presumed to be an equitable mortgage. The true intention of the parties must prevail. Article 1365. Example. Angeles purchased a parcel of land from Velasquez. Second example, by the terms of the document, the contract is one of sale. Third, later on, Justo bought the subject land for the heirs of Angeles. The heirs of Velasquez and should Justo contending that the contract between Angeles and Velasquez is a mortgage. Justo argued that it is a sale with the right of repurchase. However, in one of the clauses in the document, it appears that Velasquez did not reserve the right to repurchase the property, but bound himself to return the principal interest. This contract is mortgage. This contract is mortgage. Article 1366. Cases when reformation not allowed. Simple donation inter vivos where no condition is imposed. Donation is an act of liberty whereby a person disposes gratuitously of a thing or right in favor of another who accepts it. When the donor intends that the donation shall take effect during his lifetime, it is a donation inter vivos. It is distinguished from donation mortis cause in a that this kind of donation takes effect after the donor's death. In donation, the act of essentiality, gratuitous, and the donee has, therefore, no just because the cause for complaint. If in the deed of donation a mistake of defect has been committed, it is a mere failure in a bounty which, as a donor, was not bound to make. He is not bound to correct. Of course, the donor may ask for the reformation of deed of donation. If the donation is conditional or a one ruse in character, the deed may be reformed so that the true condition imposed by the donor or the real intention of the parties might be expressed. Wills. A will is an act of whereby a person is permitted with the formalities prescribed by law to control to a certain degree the disposition of his estate, to take effect after his death. Like a donation, the making of a will is a strictly personal and free act, which cannot be left to the discretion of a third person. Hence, upon the death of the testator, the right to reformation is lost. Furthermore, a will be revoked by the testator any time before his death, and this right is not subject to waiver or restriction. Where the real agreement is void, if the real agreement is void, there is nothing to reform. Reformation would be useless because the real agreement being void, it is unenforceable. Illustration. Jellyby donated the trademark for his fried chicken to Mangdo without condition. In this case, the act is essentially gratuitous and Mangdo has no just cause for complaint.
Article 1367. Based in estoppel, Article 1431 or ratification, when a party brings an action to enforce the contract, he admits its validity and that is expressed the true intention of the parties. The bringing of the action is thus inconsistent with reformation. There is no prohibition of instrument and its enforcement as reform. Kapag ang isa sa mga partido ay nagsampa ng aksyon upang maipatupad ang instrumento, hindi siya makakahiling ng malalim na pagbabago. Example, Anna sold Ben a car. Anna fraudulently made the contract one of chattel mortgage instead of sale. Both signed the contract of chattel mortgage, with Ben believing all the time that it was a contract of sale. Ben, therefore, has the right to bring an action to reformation of the instrument, but if Ben brings an action to foreclose the mortgage, he is said action enforcing the instrument. He cannot, therefore, subsequently ask for the reformation of the instrument to make it one of sale. Article 1368. Reformation may be ordered at the instance of either party or his successors in interest, if the mistake was mutual, otherwise upon petition of the injured party or his heirs assigned. Ang pagbabago ay maaaring ipag-utos ng sino man sa partido o tagapagmana kapag ang pagkakamali ay sa parehong partido. Sa petisyon ng partidong agrabyado o kanyang tagapagmana o tinalaga. Reformation of an instrument cannot just be done according to the whims and caprice of one or even both parties, but it is done only upon order of the court. If the mutual mistake there is not meeting of the minds of the parties, either parties or their successor in interest or their higher petition, the court for the reformation of the instrument. If mistake is not mutual, the reformation of the instrument may be petitioned by the injured party, his, hers, or assigned. An action for reformation of a contract prescribed after 10 years. Example, Brad and Lee enter into a contract whereby Brad sold to Lee the Mercedes-Benz. By mistake, the written contract and signed by the parties states that the sold Mercedes-Benz is Tesla, supposing that the contract was made by the third person through ignorance, etc. Under Article 1364. Neither the party is responsible for the mistake. Hence, either party may ask for reformation. Article 1369. The procedure for the reformation of instrument shall be governed by rules of court to be promulgated by the Supreme Court. However, the Supreme Court has not yet promulgated the procedure for the reformation of instrument. Under Section 7, Rule 130, Rules of Court provides evidence admissible when original document is a public record. When the original of a document is in the custody of a public officer or is recorded in a public office, its contents may be provided or proved by a certified copy issued by the public officer in custody thereof. Summary: Reformation of instrument is the remedy in equity by means of which a written instrument is made or confused so as to express or conform to the real intention of the parties when some mistake or error has been committed. Contracts that cannot be reformed are simple donation inter vivos wherein no condition is imposed, wills, and when the real agreement is void. The requisites of reformation are meeting of needs between parties, a valid contract, instrument does not express the true intention of the parties, failure of intention is due to mistake, fraud, inequitable conduct or accident, and there must be clear and convincing proof.